On April 29th, the President issued a memo in response to the large number of people apprehended at the southern border this year. The memo directs the Attorney General and the Secretary of Homeland Security to propose regulations within 90 days. The memo proposes 3 major changes that will significantly alter long-established practices in asylum law and processing. First, the regulations will establish a fee for asylum applications. Second, they will restrict the type of relief asylum seekers may apply for. And lastly, these regulations will bar people who entered between ports of entry without being inspected from receiving a work permit. Overall, these proposed changes would curtail the due process rights of asylum seekers, while still failing to ensure orderly processing of those arriving at the southern border. For the first time in U.S. history, a fee will be imposed on asylum applicants. Requiring a fee for asylum applicants contradicts international laws and creates a financial barrier for humanitarian protection. People fleeing violence and persecution are among the most vulnerable populations of people, and often leave their homes with little more than the clothes on their backs. Forcing them to pay a fee could be an insurmountable obstacle. Secondly, the regulations would force asylum seekers into special, limited types of removal proceedings that would restrict what the judge could consider, including limiting the type of relief and the ability of the asylum seeker to be released from detention on bond. Specifically, this means that individuals who have been victims of serious crimes or trafficking, or children that would be eligible for special immigrant juvenile status due to abuse, abandonment, or neglect, would be excluded from the protections that Congress provided. In addition, these individuals would be subject to indefinite detention while their asylum claim is pending. Lastly, the regulations would block many asylum seekers from obtaining employment authorization until relief has been granted. This would mean that numerous asylum seekers currently stuck in the immigration court backlog would be unable to work and provide for themselves and their families while their case is pending adjudication. Many people wait more than a year for their cases to be decided. Until the courts can process cases more efficiently, this change means that asylum seekers will not be able to financially support themselves. While AILA supports having an efficient asylum system that ensures orderly and timely processing of cases, this memo and the regulations it calls for would create chaos in the immigration courts and disrupt an already dysfunctional processing system. It does this at a great cost, namely, diluting due process in a way that deprives asylum seekers the meaningful chance to apply for protection. To address the situation at the southern border, the government should fix the immigration court backlog by reforming the immigration courts, ensure access to counsel for asylum seekers, and address the root causes of migration by increasing, rather than cutting, foreign aid to the Northern Triangle countries.